Hey everyone, it's me, Unique. Of course, I'm a real estate agent here in Dallas, Texas. I'm back with another video, of course, whether you like it or not. And this is a recap from my video yesterday when I was at eviction court. Now, some of the things that I just want to mention in this video is things that I had come across while I was there in court on basically things I otherwise wouldn't have known unless I was there. And clearly, I'm not just the only one, because there was a couple of other attorneys and agents of property management that got turned away for this very reason. Now, ironically, this reason didn't apply to me, but I see that it is something that people need to pay attention to. And one of them, like I said in my video, has to do with a home being backed by a government-backed entity like Fannie Mae. Basically, the reason why that played a key role here, not necessarily in the tenant winning over the eviction, but definitely was able to throw a wrench in the process and kind of slowed the motion down, because inevitably the judge ordered the agent or the attorney to go back and basically resubmit and start the process over again. And the reason for that is that when it's a government-backed loan that for the home that the tenant is in, you cannot do a regular Texas 3-day notice. You have to do a 30-day notice, and that's because the home qualifies for what they call the CARES Act. So if the home is under a government-backed entity, it is covered by the CARES Act. So anyone in there that's needing to give notice for non-payment of rent, she was very specific about that, but non-payment of rent, if the home is under a government-backed entity like Fannie Mae, you have to give them a 30-day notice versus a 3-day notice. So what was getting kicked out was a default in which the notice was provided. Those homes that the tenant was in, the attorney immediately said, "Judge, they gave the tenant a 3-day notice and the home is backed by Fannie Mae. We need a 30-day notice, so the process needs to start all over again." So it's basically a wrench in the play to prolong the time. Also, with Section 8, you have to notify housing first about the eviction before you go straight to eviction court. Some of the agents and landlords and property owners submitted a request for eviction through the courts without going to housing first. That also got them turned around. So if you have a Section 8 tenant in your home, you need to go to housing, let them know about the eviction before you file the eviction in court. That time frame between when you need to notify housing and when you can file it in court, she didn't say, but I just know that timeline, because that first initial notice to housing was not submitted first, she turned it around and had them start the process all over again. So very interesting. Love you.